So thank you all to our speakers, Richard, Andrew, and Samuel. I want to give you each just about 30 or 40 seconds to wrap up any final thoughts you might have you want to share with our attendees today. Richard, we'll start with you.
Okay, so first and foremost, executory contracts, or whether or not a contract is executory, can be a critical element as to whether or not a debtor can reorganize its affairs and emerge from bankruptcy. So it is critically important to get copies of all agreements as early as possible in the representation, and to review them extensively, analyze them, and understand what rights, what remedies, and what value there is to each of those agreements.
Thank you so much. And Andrew?
Sure, thank you. I would just add that Section 363 sale processes, when a debtor is selling assets in a bankruptcy, are moving at faster and faster rates as the cases develop. Debtors lawyers like me want to get in and out of bankruptcy as possible, because bankruptcy can be very expensive to the company that we're trying to reorganize. So if you're a contract counterparty, get involved early, read the documents, understand what's going on, because if you sit on your rights, you could be bound to something like a $0 cure payment, or having your agreement assumed to a contract counterparty that you don't want to do business with.
Thank you so much. And Samuel?
Yep, thanks. First of all, I've enjoyed this. I really appreciate Andrew and Richard for doing this with me. It's been a lot of fun. The courts have described this as a psychedelic area. That I hope it wasn't too psychedelic for the listeners. It is, as Richard and Andrew pointed out, this is frequently a large part of the value in a bankruptcy case is in trying to sort out the executory contracts and their ability either to be monetized through a sale and assignment or rejected to cut losses for the operating company. And as we've all talked about, sometimes the analysis can be difficult for both legal reasons and also practical reasons. So, I urge everybody to, this is an area that requires a lot of attention throughout a bankruptcy case, including in the preparatory part. And I hope you've all learned something today. I know how you have. Thanks.